In 1880, equitable morality clashed with business practices in a landmark telegraph case.
I have had since illustrated the difference between the morality of a court of equity and that which prevails in the business world. It was 1880, and the case was a bill for an injunction and relief brought by the Atlantic and Pacific Telegraph Company against the Baltimore and Ohio Railroad Company and the American Union Telegraph Company. The complainant telegraph company, without written contract, had been, since 1870, under a verbal arrangement with the Baltimore and Ohio, accompanying with its wires and part with its poles, the right-of-way of the Baltimore and Ohio Railroad Company for the purpose of the joint business of its own and of the Baltimore and Ohio Railroad Company upon certain terms as to expense, etc., agreed upon. The Baltimore and Ohio Railroad Company, on the 28th day of March, 1880, gave notice that the arrangement with the Atlantic and Pacific Telegraph Company was terminated and that it would take possession of the wires and poles, etc., on the 1st of March following. This it did in a clandestine manner of an important part of the circuit of the telegraph company, and on the same day it took possession, it entered into an arrangement as to the use of the wires in the transaction of the telegraphic business with a rival telegraph company, the American Union Telegraph Company, a co-defendant. Yeah, so that's a lot there.
Yeah.
Yeah, so basically you got several companies sharing electric pole space, and there's a railroad involved under a verbal agreement, and someone terminated it without notice.
Yeah.
So, the court held that under the verbal contract, the Baltimore and Ohio Railroad Company, at law, had the right to terminate the verbal arrangement and take possession without notice of the wires and poles upon its right-of-way, but that this legal right was to be exercised with the proviso that underlies every right in every contract in a court of equity, to wit, that it was to be exercised in good faith, that under the circumstances in evidence there was an attempt to exercise a legal right in a harsh and unconscionable manner, and that the exercise of the right for the joint benefit of itself and a rival telegraph corporation was not the exercise of its legal right in the good faith required by a court of equity, on the ground that the power of expulsion was used for the benefit of one of the partners with whom the quarrel was had, and that the assent of the other partners was obtained without notice to the complaining partner, and therefore the power of expulsion had not been exercised in good faith. The Vice Chancellor held that the act was a fraud upon the complaining partner in a court of equity, whatever it might be elsewhere.